days of selling cannabis, there was generally one simple trick to stay out of trouble with the law, which was don't get caught. But today, the regulated market is no doubt preferable to the dangers of the black market, but the laws surrounding cannabis at every level, from the cultivation to sale to customs to testing and lobbying, to understate it, are tricky. And while I can tell you that undercover cops do not have to tell you that they're a cop, they are allowed to lie, that's not really going to help you once you're out in the wilderness of the modern cannabis marketplace. So our next speaker, in her capacity as the self-appointed dopest attorney in Los Angeles, can, however, walk you through some of the hazier parts of cannabis law, and ideally, as she would often do in her days as a defense attorney, representing medical marijuana clinics and patients, keep you and your business out of jail, bankruptcy, or regulatory limbo. Allison Margolin is a graduate of Columbia University and Harvard Law, a lifelong advocate for marijuana policy reform, and a founding partner of Margolin in Lawrence, where her niche as an expert in cannabis laws put her at the forefront of California's legal market. She'll discuss local and state laws on disclosure in California and the more cumbersome elements of federal customs and malpractices, including foreign investments in U.S. companies. She'll also tackle how to navigate conflicts of interest in the industry, as well as the fine line separating lobbying and bribery. And if you have any questions, feel free to send them up, and we'll have a Q&A after presentation. Please welcome to the stage Allison Margolin.
Hi everyone, I'm a little sick, so you'll have to forgive me. But given that, I'll try to be as clear as I can. It's nice to see everyone and thank everyone for coming. I'm really happy to be here and that we can be discussing criminal law in the context of legalization as opposed to how it was in the olden days just a few years ago. But the new landscape also presents very different potential issues for companies and businesses that people, especially in the marijuana business, are very unfamiliar with sometimes, especially people who come from kind of the old regime to the new regime. So I'll start with a little bit of kind of history, a very brief little history. So basically, in this kind of will just contextualize where we are and why we're dealing with, a different type of criminal issues than we did conventionally. So marijuana was criminalized, obviously in the 20th century in California. And in 1996, the state decided to start reforming the marijuana laws, and that's when we had our first basically defense to marijuana possession, and that was with the medical marijuana laws. And the way that worked is that the marijuana laws at that time were simply an affirmative defense, the way that like if you kill someone in self-defense, that you have an affirmative defense. But you still have to go to court, go through potentially a preliminary hearing, a trial, and then you can put on, at some point your defense and maybe win. And that was how it used to be for marijuana from about 1996 until 2016. And what happened in 2016, as you all know obviously, is that in California, recreational marijuana was legalized pursuant to Prop 64. Before that, all we had done is simply have statutes that were added to our health and safety code that kind of just decriminalized certain activities, but like I said, it was an affirmative defense. What the main difference for that is that if you're a license holder in the Prop 64 world, post-Prop 64 world, the difference between having a license and having a defense is the police aren't supposed to come in with a license and do any raiding. They're not supposed to arrest you. And actually, generally, that's happened throughout the state. So since legalization, people who have licenses for cannabis activities generally don't get in trouble for committing health and safety code violations like they did in the past. One exception to that is Santa Barbara County. And the issue with these, which is very interesting with criminality in California and the cannabis landscape, is that what's criminalized and what's enforced all depends upon the local government. So whereas most of the state, if people have licenses, they're not being sought after by law enforcement. In Santa Barbara, for example, the sheriffs there and in San Luis Obispo in the earlier part of this year, they decided that they were going to go after all the licensed entities on the theory that they had obtained their license in a perjurious way. So Santa Barbara's ordinance, which is similar to a couple other ones, actually required people who were engaging in the new Prop 64 activity to sign an affidavit that they had previously been growing. And what happened this year was that the sheriffs came into Santa Barbara to the licensed entities, started cutting down the cannabis on the basis that the license was obtained through perjury. They were saying that the person was lying about having grown marijuana. So that's a very unusual way for law enforcement to be, but I still point it out because it's important, because in terms of an economic perspective, based on the way that Santa Barbara enforced and the way that they went after people through criminal prosecution versus licensing violations, we kind of took out a huge amount of our outdoor and mixed like cannabis product in the state. So this past year, that was like as a result of raiding like 12 cultivations in Santa Barbara. So these criminal things that happen actually have a huge impact also on the cannabis market. So that's one way in which the government can decide whether or not to use now criminal or licensing violations. That's basically what happens in like the modern day. The government, meaning the state, but really the local government, decides whether or not if people commit license violations, are they going to go the old-fashioned way or the license violation way. Now, the way the law is written, it's pretty clear that if there's a violation within the licensing scheme, that's supposed to be an administrative regime. But unfortunately, of course, the law is only as good as those who enforce it. And if those who enforce it and interpret it differently, then obviously the results can be variable. But Santa Barbara is pretty much an outlier. And throughout the rest of the state, when people have issues involving their licensed cannabis activities, the local governments have ordinances that require that the way those are handled is through the local licensing administrative process, not through the criminal justice system. The most common thing, though, that's kind of coming up as an issue and a potential criminality, like I said, Santa Barbara is kind of an outlier. But one big issue that we're having is this issue of foreign disclosures. And everyone's kind of, I think probably most people here have heard of, like there was a recent indictment in the cannabis industry in Sacramento over an issue of, it was a complicated kind of political issue, but of relevance here. One of the charges that was indicted had to do with basically not disclosing the financial interests of a cannabis company. And the reason why this becomes an issue quite often for people who are dealing in the industry is that a lot of the money that's coming for the cannabis industry is coming from outside the country. And under California law, that's totally allowed. In fact, the fact that California allows foreign investment is one of the reasons we have such a burgeoning, well, we did until recently have such a burgeoning economy here with cannabis. And it still is one of the most flexible ones. So under our state law, we allow foreign investment. The issue is that this comes into contrast with our U.S. customs and immigration laws. So on the one hand, you're supposed to disclose anybody who has an interest in cannabis, wherever they are. That person is then supposed to come to California to get live scanned, because you need to get live scanned, which is like getting your criminal record from the state and federal governments in order to be able to even have a license. But if the foreign person comes to the United States for the purpose of, or even if part of their purpose is to be involved in a cannabis activity, that can actually prevent them from ever coming back into the country. So one of the, I think, bigger kind of big picture issues that lawyers and a lot of companies and people face is that, they obviously want to get foreign investment, but disclosing the foreign investment and the foreign participation may end up preventing the person from coming into the country. So that's a very frequent issue, and it kind of came up, I think, in this issue of the recent indictment with the Sacramento dispensaries. And that can only really be resolved through federal legalization. There's really no other way to really resolve that tension, because on the one hand we have these disclosures, on the other hand we have U.S. customs and immigration practices that are based upon the federal controlled substances law. And even if there's been a policy of non-enforcement in terms of the federal government hasn't been coming after cannabis businesses, each administrative entity has its own philosophy. So like customs has its own philosophy, and they definitely don't care what the policy is. And in fact, it's gotten even worse. I've even heard of, in this one way, I've heard of even like glass jars that are meant for dispensaries being intercepted at the border. So that's one of the tensions and potential criminal things that can come about because of this conflict in the law between the California disclosure laws and all the states' disclosure laws and then U.S. immigration policies. Another area that I think is going to be something people really need to watch out for is the idea of being potentially prosecuted for allowing a non-licensed entity to run your licensed company. And that sounds kind of complicated, but what I'm talking about is white labeling. So a lot of people have an idea that they're gonna basically be hired and share profits with a marijuana company. Let's say you have like a celebrity that wants to promote a marijuana company, wants to take profits from it, and wants to be able to promote it. In order to do that, that person has to be disclosed to the city and the state, and they have to be on the company. And it's actually more than just a technical issue. There's a whole body of law, which is under the Business and Professions Code, that prohibits a license holder from allowing their licensed business to be run by a non-license holder. So like this area of law comes from like this basically practicing dentistry without a license. There have been prosecutions, and I've been involved in defending one for the past 5 years, where a marketer for a marijuana recommendation clinic was accused of sharing profits with marijuana doctors, and yet he's not the license holder. And in that case, he can't even be one because he's not a doctor. But the same principle applies in terms of any kind of license activity. So if you have a license, you can't allow someone who's not disclosed as an owner of the license to be controlling what that licensed activity is. So that comes up quite a bit, actually, because of people's interest in white labeling and branding. And I think that so far, I haven't seen any prosecutions under this idea, but I definitely know from having been, in addition to doing regulatory work, having been a criminal defense attorney for so long and been involved in a 5-year-long case on this Business and Professions Code, that once the district attorneys start becoming hip to these issues, it would probably be something they'd be interested in prosecuting. And there's also kind of a bigger element to that, which is that on a bigger level, the prosecutors locally in California don't have as much to prosecute these days. First, we have, as you guys know, the decriminalization of marijuana, but even before that, all drug possession was decriminalized in California, meaning that drug possession is a misdemeanor. In addition, we've had, obviously, exposure of police brutalities, and our mayor has been really progressive about searches and seizures and obviously stopping drivers who shouldn't be stopped. So that kind of leaves our district attorney's offices with needing things to do, which is why I'm kind of alerting you guys to this area that could become a problematic area with the license holders. Kind of related to that also is something that comes up all the time and has been in the news here in LA, in the newspaper even this week. What about management companies and how much control can they have with respect to a license? So an issue that comes up very commonly, especially in the recent LA retail licensing period we just had, is can a management company, of course they can do business with the license holder, but what are they allowed to be doing? Can the lease be in their name? Is that holding too much power? Is it not holding too much power? If they're taking a percentage of profits, in order to take a percentage of profits for a license holder, and this is just the general licensing business and professions code area, the percentage has to be reasonably related to the work that you're doing. So another area that I think could become an area for criminal prosecution, and so just something to be conscious of, is the way that these management company agreements are written. And if they're written in such a way that they're taking away control and power from the license holder, and if the facts of the scenario also suggest that, then that can be fodder for a ton of criminal prosecution. And the DAs can be very creative. In this area, like I said, I haven't seen this happen yet, but I'm kind of giving you guys what I see as potential future prosecutions once people in law enforcement kind of start to understand what's going on in terms of these management agreements. And then, unfortunately, once you're prosecuted for a business and professions code that involves a licensing issue and a management agreement, then you can end up getting prosecuted for federal tax evasion and state tax evasion, all sorts of other things that kind of come from having what they might consider a criminal conspiracy. So you have to be really careful when you're writing your agreements, and obviously have an attorney who understands this area of the law and the criminal area of the law in terms of the business and profession code, because you could be write an agreement that is literally, giving evidence to a district attorney. And I think that's one of the kind of larger weird issues that we deal with in the cannabis criminal and like regulatory arena, is that because the federal law is as it is, when you're complying with state law, you're obviously admitting to a federal crime. But because there's been a policy of non-enforcement against license holders, it's a risk that people are taking, obviously, because you'd rather be doing what the law tells you to do and then not getting in trouble with the feds than not having an agreement. But at the same time, since we're doing things a different way than in the olden days where there was just like pay-and-o sheets that would be like discarded versus putting things in a computer database and a OneDrive and a Dropbox, that you have to be very careful when you're writing agreements, especially when you're writing agreements concerning something that's still federally illegal. And given what I'm kind of explaining to you about these management agreements, you just have to be very careful whenever you're doing any, obviously, documents, that you're not somehow putting yourself into a criminal problem. The last area that, one more area in terms of that might come up will also be conflicts of interest. So in the cannabis arena, which is different than in the alcohol arena, you can actually own every kind of license, except you can't own a testing license and any other kind of license. So in the cannabis arena, you can be a retailer, a distributor, a cultivator, manufacturer, but you can't do any of those things and also have a testing lab. This is obviously really different and actually less stringent, as I'm sure some of you know, than in the alcohol world, where you can't be a retailer and a distributor. It all has to be separated. But that being said, people still can be prosecuted here, obviously, if they have interest in a cannabis testing facility, as well as in any other cannabis type of activity. And the last area that I think is probably one of the more interesting and comes up all the time is what can you do to get your license going? And what people generally do is they lobby to the local governments. Well, this lobbying to the local governments has also become kind of an area where bribery can happen and many other aspects of criminality. And we've actually, just this last 2 weeks, there was an article in the LA Times about one of our city council offices where one of the assistants was just terminated, and he's filing a lawsuit against the city council saying he was terminated because he was talking to the FBI about illicit bribery-like things with the cannabis arena. What's really disturbing is when you're actually dealing with people who you suspect to be in those positions, and we definitely have experience with that, and that can be really hard as someone who's applying or someone who's an attorney even. So let's say let's say you're in Los Angeles and you want to apply for a retail facility through what's called this Public Convenience and Necessity Program, which basically allows you to go right to the city council. You get to the city council, there's no real guidelines about it, and what do you do if you go to the city council assistant and they tell you, well, we're going to let you in if you donate $10,000 to, the Fred and Ace Club. Do you donate the money to the Fred and Ace Club, or do you not and risk not getting your license, and at the same time maybe you don't and you also won't get indicted over it? So those are some of the really, I think, hard things and very common things that happen, because obviously in order to accomplish a lot of what we need in this industry, like any other political arena, it requires lobbying. But for some reason, the cannabis arena has attracted a lot more problems in that area even than it generally attracts. And just in the last couple of years, the feds have indicted quite a few cities and mayor's offices, for some reason, a lot of times along the 10 freeway. I don't know why we have that issue. But that's happened throughout the last several years over people engaging in bribes. And of course, you want to be participating in the lobbying process, but it can be hard as even an attorney or as an applicant to know what is okay to do, what's not okay to do. The cities are trying to develop more rules about it. For example, in Los Angeles, they have what's called a developer ban on funding. So they try to create rules that would make it such that a person wouldn't get caught in the middle of something that's confusing like that. But that being said, it's still an arena that's quite confusing, especially when you're meeting with people that you suspect have issues, and at the same time, you or your client is trying to get through the process. So those are kind of some of the very sticky issues that occur during this. And there's, of course, the federal law, which I'll touch upon for a few minutes. Fortunately, in the last few years, there haven't been any federal prosecutions that I've at least heard of for people who are engaging in only licensed cannabis activity. However, if you're, let's say, engaging in licensed cannabis activity as well as illicit activity, and actually this is extremely common, and the reason why it's extremely common is there's all these hurdles for people to get their licensed activities off the ground. It can take 500 days to get an electricity upgrade. It can take quite a while to get sprinklers put in. Then people are still paying their rents. So a lot of the people in the cannabis industry are actually still participating in illicit cannabis activity while they're trying to get their legal operations up and going. So it's more of an issue than you would imagine. Unfortunately, the federal case law on this point is not very good. And there's a case called U.S. versus Climate. Unfortunately, I did the trial in this case. And in that case, the Ninth Circuit actually decided that if you are doing illicit activity as well as legal activity, the feds can add up all those quantities and sentence you on both. So obviously it's really important not to be doing that. And the good news, like I said, is that in the last couple years, there haven't been prosecutions that the way there were even just 5-6 years ago in that way, because now we have companies who are transacting businesses within states. We don't have people as often doing that and then mailing 80 kilos to Pennsylvania. But that being said, there still are a lot of people who are subsidizing their legal businesses with illicit cannabis activities. And until the federal laws change, they're subject to mandatory minimums for that. So I would say, kind of to summarize, to keep companies out of jail, out of federal prison, out of the locals, number one, they should definitely have an attorney, not try to do it themselves. Number two, have to be conscious of this foreign disclosure issues. That's extremely important. There's obviously a lot of foreign money involved because conventional money still isn't available through the banks. So these are private citizens and the law allows it, but we have to kind of make an effort to figure out how we're going to require disclosure at the state level and still not make it that people can't come into the country, because if people can't come into the country, they can't even get their live scan done for their license, so they can't even then have the license. So we do have this conflict, and it does need to be resolved. On the state level, I think that we need to put more pressure on the city governments, like places like Santa Barbara, that to encourage the governments to go after people in an administrative way, not through the criminal justice system. Obviously, that's contrary to the spirit of Prop 64. And when you have outliers like that, Santa Barbara, where they decide to go to the criminal system instead of what the law decides that they should do, which is actually going through an administrative process, you're potentially taking out hundreds of acres and a huge economy. So like in this last couple months, was in the beginning of the year, when Santa Barbara took out the 12 places, that was several hundred acres. And these economic changes can happen very quickly just by virtue of how the criminal law is used. And then finally, just being aware of conflicts of interest. If you are a company that's involved with cannabis testing, none of your people that are, this is where it gets kind of confusing. Does it mean you can't even have a share of that kind of company and a share of another kind of company? It does mean that. So one has to be conscious, even when you're dealing with shareholders and figuring out who you want to be part of your company, what are their other cannabis interests? Because if the shareholder has an interest in something that's a conflict, then you're not going to be able to get a license, or it can put your license in jeopardy or subject you to criminal prosecution. Of course, don't lie in these affidavits, but unfortunately, it's kind of like a double negative when you're saying that you were growing, and then the government's saying you're not, but of course you have no evidence of it because it was illegal at the time. So these kinds of little witch trial things still happen a little bit, but less and less often. And then in terms of dealing with city councils, I would say in terms of like my advice to stay away from any potential issues is that when you go into your city council meetings, you always bring somebody with you, and you always talk about what you can bring to the community and ask what the community might want you to bring. But once someone tells you that you have to contribute to this organization or that organization, you should run and I guess call me, and we'll figure out what to do at that point. But better to do that than be involved in a federal indictment. So the good news is that the landscape now is much better. People are operating businesses successfully throughout the state. They're generally not being charged criminally. But if people listen to, I think, my suggestions about what the potential criminal problems can occur, then I think it will continue to be like that. Thank you so much.
Thank you. I think we have time for just one quick question, so just want to.
Oh, she's over here. Oh, thank you.
Over. Yeah. You talked a lot about a lot of the pitfalls that could happen when companies are looking to make partnerships. What are some of the lookouts? What are some of the red flags that to be aware of?
Well, I would say one, have the person get their own live scan. So this is kind of a simple thing, but in order for someone, you can't really figure out someone's criminal record. So you actually just tell the people you might want to be involved with, go to a live scan place, which they're like on every corner, and get a live scan so you're aware what their whole FBI and criminal record is. That would be, I would say, a first. And then asking people to disclose to them all their cannabis financial interests. And then obviously having an attorney do due diligence on them, which would involve like looking them up on Lexis or like another research tool and trying to just make sure that the person doesn't have any other interests.
Great. Well, thank you so much.
Thank you.
Yeah.
Thank you, everyone. I appreciate it.